We shall now move on to the next inchoate offense, which is conspiracy. Now, conspiracy, the key thing to conspiracy is that there must be an agreement, right? There must be an agreement, and it is between two or more people. Under English law, there are two kinds of conspiracy. There are common law conspiracy and statutory conspiracy. The important part would be on the statutory conspiracy, but we will still cover common law conspiracy to see some of the old law and conspiracy which may still be applicable. But generally, conspiracy will come under the Section 1 of the Criminal Law Act 1977. So under common law conspiracy, right, you see that in the case of Jones, as mentioned, there must be an agreement, right? There must be an agreement for there to be a conspiracy. In the case of Ardalan, it was held that the agreement between all parties did not be reached at the same time, nor do all parties have to be in contact with all the others. So a conspiracy may include a lot of people. They may include like 10, 20, even 30 people also, right? There's no limit to it. And it doesn't matter if some people in the conspiracy are not in contact with other people in the conspiracy. Okay? And it doesn't matter also if some of them actually join the conspiracy a bit later. They don't have to join the conspiracy at the same time. All right? So as long as there is an agreement, then you will see that there can be conspiracy. And in Polterer's case, this was the case that confirms the incorrect nature of this offense. The conspiracy does not need to be put into effect. So keep this in mind when we are dealing with exam questions, especially when we're dealing with problem questions. If the conspiracy is put into effect, then normally we will talk about whether the parties are liable for that offense or not. So for example, if it is a conspiracy to commit robbery, and if the robbery was actually executed, then we will discuss whether the parties are liable for offense of robbery or not. But if there was just an agreement to commit robbery, and then in the end, no theft was committed, no robbery was committed, then we will talk about whether was there conspiracy. Because if we can charge them for robbery, then we don't need to charge them for conspiracy to commit robbery. So keep in mind the incorrect nature of this offense. So common law conspiracy, in the case of Mulcahy, it defined it as agreement by two or more to do an unlawful act or to do a lawful act in an unlawful way. So this is quite similar to the definition of conspiracy that we saw under the Penal Code when we dealt with the issue of abettors under Section 107 about conspiracy, and also Section 120A, right? You may want to revise your notes on that. So it's quite similar, okay? Agreement by two or more to do an unlawful act, or the agreement was to do a lawful act in an unlawful way. And under common law conspiracy, there are only two types of conspiracy that remains, which is conspiracy to defraud and conspiracy to corrupt public morals. I'm going to go through this very quickly because, as mentioned, it's not really very important, but we need to know about it because it still exists. So first, conspiracy to defraud. And under conspiracy to defraud, there are also three kinds of conspiracies, right? There are also three ways of how you can conspire to defraud. First is that you conspire to defraud by causing economic loss with intent. The second is to deceive the victim into taking an economic risk. And finally, the third is when you conspire to induce a public official to act contrary to his public duty by deception. So first, right, conspiracy to defraud by causing economic loss with intent. This is the case of Scott, right, against Metropolitan Police Commissioner. So in the case of Scott, it actually involves the illegal duplication, right, and distribution of movies. So therefore, the conspiracy was actually to defraud the people who deserves to get the royalties from the screening of these movies, but they didn't but they are not going to get it if it was illegally copied and illegally distributed. So in the case of Scott, it was held that the defendant is guilty of conspiracy to defraud if they cause economic loss to another with the intent to cause such harm, right? To cause economic loss to another. In this case, when they duplicate and distribute the movies illegally, they are causing economic loss to the people who actually made the movie and who actually have the legal right to the royalties for the screening of the movies. So it doesn't necessarily involve deceit by the defendant of the people intended to be defrauded. So you don't have to show that the accused here or the defendants here or the conspirators here deceive the people who made the movies or deceive the people who are entitled to the royalties. Here is actually where they actually got the movies from the cinema owners. And it was held that it must be shown for conviction that there was an agreement with one or more persons, and the agreement was to deprive another by any dishonest means of something that was either his or which he was or would be or might, but for the perpetrator of the fraud, be entitled. So here there was an agreement to deprive the makers of the movies, right, the makers of the shows, of the royalties that they were entitled to. Now, the second type of conspiracy to defraud is where you deceive a victim into taking an economic risk. Excuse me. And this is the case, this illustrated in the case of Crown against Elsop. And the Crown against Elsop is regarding a hire purchase company. Now, hire purchase is something that you will take up when you want to buy a car, right, in the future, if you haven't bought your own car yet. So during my time, at least among my circle of friends, when we first get a car, we always talk about getting a Proton because that was the cheapest car around. So I know that for some of you in the circles that you're moved, maybe the car that you're thinking to get is could be something a little bit more fancy, a little bit more expensive, right? Or you may want to get something a bit more practical, like a van, or I guess something which is a bit more useful, perhaps in the Malaysian traffic, maybe. Yeah, how about this? The tumbler. Okay. Well, whatever it is, right? Normally, when you want to buy a car, because the car is so expensive for normal, ordinary people, you don't really pay for the car at one go. Okay, you don't really pay everything. Some people do that, but most people don't. What they do is they take a hire purchase. That means that this hire purchase company will buy the car on behalf of the person who wants to buy the car. Let's say I want to buy a car. The hire purchase will pay the car company the full amount, right? And then they will let me have the car. And every month I will have to pay back the hire purchase company a certain amount of money plus interest, okay? So that the hire purchase company will be able to make money from that transaction. So what happened in this case of LSOP is that it actually involves an independent broker. That means this person, he doesn't work for the hire purchase company, but he helps the hire purchase company by looking for potential customers. And when he finds potential customers, he teaches them to fill in the forms, hire purchase forms, and basically, he tells them not to tell the whole truth, right? Don't have to be very truthful in filling in the forms, because for some people, if they are too truthful, the hire purchase company may not give them the hire purchase. So by doing that, according to the accused here, the hire purchase company would get customers, and the customers will get their car. So it's a win-win situation. Okay, except that it is not for him. So it was held in the case of Crown against Elsop that where a person intends by deceit to induce a course of conduct in another, and in this case, he basically deceived the hire purchase company into giving the hire purchase to the customer. And this put the hire purchase economist's interest in jeopardy, right? Then he is guilty of fraud, even though he does not intend the actual loss should be ultimately suffered by the other. So even though the broker here did not intend the hire purchase company to suffer losses, but his act of deceiving them, together with the purchaser, puts the economic interest in jeopardy, and and the agreement with the purchaser to actually deceive the hire purchase company, it can amount to a conspiracy to defraud because they deceive them into taking an economic risk. And finally, the third type of conspiracy to defraud is the inducing a public official to act contrary to his public duty by deception. And this is illustrated in the case of Vellum and DPP. So, as the title itself indicates, this involves inducing a public official, someone who works for the government, basically to act in a way that is contrary to his duty. Okay, you induce him to do that by deception. So, in the case of Vellum, it also deals with hire purchase forms and agreements and credit sale agreements. And for some of these agreements, because it involves large amounts of money, they need to also get the permission from the government. They need to get consent from the government. So what they did was that they actually also tried to deceive the government, which is basically deceiving the public official, who is going to look through the documents by not being truthful and filling in the documents. So they hope to deceive the public official when he checks through the agreements and basically gives them the green light to go ahead with the agreement. So it was held that the intent to deceive a person responsible for a public duty into doing something that he would not have done but for the deceit, or not to do something but for the deceit, will then amount to intent to defraud. Okay, so those are the three types of conspiracy to defraud. So you see that there is deception that needs to be committed, and there is or at least there's a dishonest intent. And the second type of common law conspiracy that still survives to today is the conspiracy to corrupt public morals. And this is illustrated in the case of Nuller against DPP. It was actually created, this offense was actually created by the House of Lords in the case of Shaw against DPP. And the case of Nuller against DPP, it confirms that this offense still exists and still carries on, right? In spite of the fact that there is a statutory conspiracy also. Okay, so it's a very specific type of conspiracy to corrupt public morals and outrage public decency. So Nuller and DPP is basically a case regarding a magazine which caters towards the gay community. And then there were classified ads where the people who put in the ads were very specific and very explicit in what they want to do. So they were charged, the publishers of the magazines were charged for conspiracy to corrupt public morals by actually printing and distributing this kind of magazines and to outrage public decency. The Court of Appeal defines the terms of public morals, public decency, and what it means to corrupt and outrage. So as they see a standard sense of propriety, and here, because of the inquiry nature, there is no requirement that anyone is actually outraged or corrupted, but there's a conspiracy to actually outrage the public decency or to conspiracy to corrupt public morals. Okay, so that's basically it for the common law conspiracy, and we're going to spend a little bit more time on statutory conspiracy. So as alluded earlier, statutory conspiracy is found under the Criminal Law Act, specifically Section 1.1. And according to the Criminal Law Act, Section 1.1, for there to be a statutory conspiracy, there must be an agreement. And the agreement is that a course of conduct will be pursued. And if this course of conduct it is carried out in accordance with their intentions, it will amount to a crime, or it would necessarily involve a crime. So these are the elements for statutory conspiracy under Section 1.1 of the Criminal Law Act. So the first thing that we need to see is that there is an agreement, right? There is an agreement. And the agreement is to pursue a course of conduct. In the case of Crown against Anderson, this was a case where the conspiracy was basically an agreement to help somebody break out of the prison. Okay, if you want to watch a good prison break movie, actually it's not really a prison break movie. I guess you can say it's a prison break movie. The Shawshank Redemption, one of the classic best movies on this. So what was agreed was that he was going to provide wire cutters. He was going to provide a rope ladder. He was going to provide a getaway vehicle, and he was going to provide a safe house. Right? This is what he agreed, but in actual fact, he was only going to provide the wire cutters. That's all. Right? He was only going to provide the wire cutters. But it was held that he was still guilty of conspiracy. Right? So a person may be guilty of conspiracy even though he secretly intended to participate in only part of the course of conduct. But there is still an agreement to participate in it. So even if it is only part of the conduct, it is still sufficient to be guilty of conspiracy, right? Even if the person secretly intended to participate in only part of the course of conduct. And in pursuing the course of conduct, we'll see that the next element would be that it would necessarily amount to an offense. So if this course of conduct is pursued, then it will amount to an offense. Now, the question then arises is that what if it is conditional on something before it actually amounts to an offense? They will do something, but it will only amount to an offense if certain conditions are met. And this was discussed in the following two cases, in the case of Crown against Reed and Crown against Jackson. Now, in the case of Crown against Reed, this was a case where there were these two individuals who agreed to help certain people to commit suicide. Yes, it was conspiracy to commit suicide, assisted suicide. So what they did was that they went around talking to certain people, perhaps the terminally ill people, and find out from them, right, what were their condition, and see whether they want to perhaps end their suffering and end their lives or not. So if they wanted to, then they would help them to. So if those people that they approached wanted to, so these two fellows would then help them to commit suicide. So at the end of the day, the agreement was there that they will help people to commit suicide. This is assisted suicide, and assisted suicide is an offense in England, right? But they will only do that if they felt that the case was suitable. So it all depends on their interview, and basically their interview, right? When they talk to them, they get all the information and then they will decide. So it's not necessarily that they will commit it, but it all depends on the response of the person and what the person tells them. They were still convicted, right? They were still convicted. Okay, they were still convicted of the offense of conspiracy and conspiracy to commit assisted suicide, even though the assisted suicide will only be done if it is conditional on certain things. In the case of Crown against Jackson, this was a case where the accused was charged for an offense in court, and he was going to lose the case, or at least he thought that he was going to lose the case, right? He was going to be found guilty. So what he did was that he actually got someone to shoot him in the foot, literally shoot him in the foot, right? So that when he goes to court, he'll go to court injured, and he's hoping that when he is found guilty, or rather if it is found guilty, then the court will be more sympathetic towards him because he suffered an injury. Okay? So in this case, the court held that they were guilty of conspiracy to pervert the cause of public justice. Right? They were guilty, right? Those who were helping him, basically the people who shot him in the leg, helped him, and they were all found guilty of conspiracy to pervert the cause of public justice. The court said that the plan did necessarily involve the commission of an offense in the sense that if the agreement had been carried out in accordance with the plan, there would have been the commission of the offense, which is to pervert the cause of public justice, right? Uh, trying to get sympathy from the court so the court will not impose a serious sentence. It was held that it was no defense that the offense depended upon a contingency which may not have taken place, namely the conviction. So at that time, they don't even know whether he was going to be convicted. So the argument was that, well, if he was not convicted, then he would not be said to have been trying to pervert the cause of public justice. But the court said that, but if he was convicted, then he will be guilty of conspiracy, and that was enough. So even if the crime or if the unlawful act that was supposed to be done is contingent, right, or conditional on something else, it is still enough to show that it's still enough for the court to find the accused guilty of conspiracy. Now, as for the mens rea for the offense of statutory conspiracy, we look at case law, and in the case of sight, the defendant and the conspirator must know or intend the circumstances of the offense contemplated. Right? So you agree to do something which may amount to a crime, but not only that, you must also know about the circumstances, or at least intend the circumstances of the offense contemplated. Now, what happened in this case was that the defendant actually owned a money changing store, right? So he runs a money changing business. This apparently, the facts, was a money changer that was located near Marble Arch in London. And Marble Arch in London is quite popular, especially among Malaysian students, because that's where the Malaysian High Commission is. And if you want to have good nasi lemak when you are in London, you go to the Malaysian High Commission, right, to eat that. That's at Marble Arch. Anyway, so he actually agreed to help someone to basically, well, help to change their money. And what they were trying to do is that they were trying to launder their money. Okay, they're trying to launder their money. Basically, it's money obtained illegally, and they want to put the money through this money changing business so that they will be able to, so to say, clean the money. Okay, so he did agree, but the court said that agreeing to help them is one thing. He must also have known that when he was helping them, he was actually helping them to launder the money. If he didn't know about that and he just agreed to help them to change the money, that would not be enough, right? The agreement to help them would not be enough because it doesn't have the mens rea. The second mens rea is that the defendant and the conspirator must intend that the agreement be carried out. So you agree on something and you must intend that the agreement must be carried out. Of course, according to Anderson, we saw earlier on, they don't have to intend for every part of the agreement to be carried out. As long as there's agreement of some part of the agreement to be carried out, that would be sufficient. And finally, the defendant and the conspirator must share the mens rea required for the offense contemplated. There's no conspiracy unless B shares the requisite mens rea for the agreed offense with A. In the case of, this was decided in the case of Siracusa, which was basically trafficking in drugs, but the court said that they must have had the same mens rea, right? They must have the same requisite mens rea for the offense that they agreed to carry out. Now, Section 2 of the Criminal Law Act prevents for exceptions for the liability or statutory conspiracy. So the first exception is that the victim cannot be held to conspire against himself. So if he's the victim, he cannot be charged for an offense that he conspired against himself, so that the offense will be committed against him. Secondly, husband and wife cannot be liable for conspiracy if they are the only party. So if husband agrees with the wife to commit a criminal act, they cannot be said to have committed conspiracy. I suppose this is because husband and wife is considered to be one. The two shall become one. So therefore, they cannot be said to have committed conspiracy. And finally, the third exception would be that you cannot conspire with, as mentioned, the victim or a person who is under 10 years old. Right? You cannot conspire with the victim, neither can you conspire with the person who's under 10 years old, because we know that person under 10 years old cannot be said to have cannot be said to be able to commit an offense. Dolly and Capex. And finally, for the trial of conspirators, it's interesting to note that if A and B are charged for conspiracy, it may be possible that one may be found guilty and the other is found to be not guilty. Okay, it all depends on the case and the evidence against them. Now the question then is, can you conspire to commit a crime that was impossible to commit? For example, can you conspire to kill Tony Stark? Right? Can you conspire to kill Tony Stark? Now that is a crime that is impossible to commit because we know that Tony Stark died at the end of Endgame. Sorry, spoiler alert, Chef said that earlier. But if you have not watched Endgame by now, you didn't know that Tony Stark dies at the end of Endgame, then you probably it's not interested. You're probably not interested in it anyway. So is it possible to conspire to kill somebody who's already dead? Because it's impossible to commit the offense. What do you think? Well, it is actually covered under Section 1.1 because Section 1.1 goes on to say that uh, the course of conduct, if which is carried out with the intentions, would necessarily amount to a crime or involve a crime, or would do so, but for the existence of facts which render the commission of the offense or any of the offense impossible. So even if the commission of the crime may be impossible, right? But there's an agreement to carry it out, there's an agreement to actually commit it, then there is still the offense of conspiracy. So interestingly, Parliament has made it that it is possible that you will be liable for conspiracy to commit a crime, even though in real life, in reality, it is impossible to commit that crime. So the act of conspiring to actually commit a crime itself is bad enough. And so that brings us to the end of conspiracy. We will be moving on next to look at the final inchoate offense, which is the offense of attempt.